Good morning from Hong Kong SAR, and welcome to the UNCITRAL Working Group 3 virtual pre-intersessional meeting on the use of mediation in ISDS. That's jointly organized by the United Nations Commission on International Trade Law, UNCITRAL, the Department of Justice of the Hong Kong SAR, DOJ, and the Asian Academy of International Law, AAIL. Today we have delegates coming from over 70 countries and regions. A warm welcome to all of you. To start off this meeting, opening remarks will be delivered by Ms. Li Yongjie, the Director General of the Department of Treaty and Law, Ministry of Commerce of the People's Republic of China, followed by Ms. Anna Jobin-Brett, the Secretary of the United Nations Commission on International Trade Law. We would now have Ms. Li to deliver her opening remarks. Ms. Li, please.
Distinguished participants, good morning and good evening. It's really a pleasure to attend this pre-intersessional meeting of UNCITRAL Working Group 3, jointly organized by UNCITRAL, the Department of Justice of the Government of Hong Kong SAR, and Asia Academy of International Law. Starting from 2017, member states of UNCITRAL initiated discussion on the potential reform of the investor-state dispute settlement mechanism. On the one hand, the system is playing an important role in protecting the rights of investors and promoting cross-border investments. On the other hand, the system is criticized, sometimes even for lack of legitimacy. During the 3 years of discussion at UNCITRAL Working Group, member states identified certain systematic issues for the system, such as lack of correction mechanism, lack of code of conduct of arbitrators, widespread and justified inconsistencies. However, the 3 years discussion also showed diversified and significantly different views on the priorities and options for the reforms. In China's view, the main reason for the shortcoming of the system is that the original design of the arbitration mechanism does not adapt to the nature of such proceeding, which should be of public international law instead of commercial. Chinese government support structural reform of the ISDS system and submit our proposal for reform last year. Coming to the topic of today, for mediation. Mediation is supposed to provide the investor and host states with high degree of flexibility and is conducive to achieve win-win situation and maintain long-term relations. However, at the same time, we also take note of the fact that although quite a number of international arbitration institutions have detailed mediation rules, including especially ICSID. However, there are few cases in practices. So, what's the reason preventing the party to the dispute using mediation as an efficient and effective mechanism to resolve their disputes? What ways to address the concern to use mediation resolving disputes, especially in the situation where one party of the dispute is government? All these questions and issues should be carefully examined and discussed. Today's meeting provides a unique opportunity to exchange views and ideas. My colleagues and I look forward listening to your insights, and I wish a success of the meeting.
Good morning, good afternoon, and good evening to all of you, or Grüß Gott, as they say here in Austria. Director General Li Yongjie, Madam Secretary Teresa Chen, distinguished moderators, speakers, delegates of Working Group 3, ladies and gentlemen, dear friends. On behalf of the UNCITRAL Secretariat, I would like to extend my warm welcome to all of you to this first virtual and first pre-intersessional meeting on ISDS reform. As part of the work on ISDS reform, we have hosted intersessional meetings in Korea, in the Dominican Republic, and in Guinea in the past couple of years. These meetings were crucial in raising awareness about the issues being considered by the working group and for sharing regional perspectives. As the working group entered into the third phase of its work, the objectives of these intersessional meetings hosted by interested states have changed to become more focused on developing of reform options being considered by the working group further. The intersessional meeting on the use of mediation in ISDS, to be hosted by the People's Republic of China in Hong Kong, originally in June 2020, was supposed to be the first of that kind. Now, as we all know, the current circumstances brought by the ongoing COVID-19 pandemic has changed our methods of work. We had the first hybrid meeting of Working Group 3 last month on the video platform with interpretation in the 6 UN languages. We had numerous webinars on a wide range of reform options on Zoom, hosted with, among others, the Academic Forum. You were all invited to informal consultations on the resource requirements of the working group on Teams. And thus we are here together to participate in the first virtual meeting wherever you are around the globe. As Hong Kong, China would like to invite all of you to an in-person intersessional meeting next year, we have decided to call this a pre-intersessional meeting, a gathering to share our perspectives on investment mediation till we meet again in person in this beautiful harbor, the fragrant harbor of Hong Kong. As many of you know, the use of mediation in ISDS was discussed during the working group session held last month. There was general interest in working on mediation and other forms of ADR being here alternative to arbitration, with a view to ensure that such mechanisms could be more effectively used in ISDS. It was observed that ADR methods were still largely underutilized in ISDS, and that there was a need to address structural, legislative, and policy impediments faced by governments on their use. On the way forward, the working group requested the Secretariat to prepare model clauses reflecting best practices on the amicable settlement period to make good use of what is still called a cooling off period, but should definitely become a period that enables and is conducive to mediation. It also asked the Secretariat, in doing so, to compile guidelines or recommendations on how to use such period more effectively. Furthermore, as a matter of information sharing, capacity building, and awareness raising, the Secretariat was requested to prepare guidelines and best practices for participants in ISDS mediation, covering matters such as the organizational aspects that states might want to consider at the national level to minimize structural or policy impediments, the representation of public interest in mediation, the setting up of a list or roster of qualified mediators in the field of ISDS. Lastly, the Secretariat was requested to work with interested organizations, such as our colleagues and friends from ICSID, to develop or adapt rules on mediation in the ISDS context, as well as model clauses that could then be used in investment treaties or in a potential multilateral instrument on ISDS reform that would apply to existing treaties. So we do have quite a lot of work ahead of us. But it is not as if we have to start afresh. Groundwork has already been done. As you know, the The Singapore Convention on Mediation entered into force last September, with 6 state parties who have ratified the convention and 53 signatory states, including China. The success achieved thus far is truly extraordinary. And the entry into force, which occurred just little over 1 year after the convention opened for signature, is also truly remarkable. The growing interest in mediation fueled by the Singapore Convention will no doubt assist in our endeavor to promote mediation in the context of ISDS. In conjunction, the Commission is expected to adopt next year the revised set of rules on mediation, as well as guidance notes for the mediation process at its next session in 2021, which will also be relevant and timely. Let me conclude by reminding you that the United Nations General Assembly has recognized that the use of mediation results in significant benefits, such as reducing the instances where a dispute leads to the termination of a commercial relationship, facilitating the administration of international transactions by commercial parties, and producing savings in the administration of justice for states. Promoting the use of mediation in international trade and investment facilitates resolving conflicts without going through formal and sometimes lengthy and costly adjudication procedures. And this fits perfectly with all the topics that the panelists will be discussing today. The discussion will not only contribute to the Secretariat's preparatory work on the topic, but also pave the way for the discussions to be held at the working group and hopefully soon at an intersessional meeting that will be held in person. I look forward to a fruitful exchange of views. Many thanks, and although I'm joining you through a recording as it's 3 a.m. now in Vienna, I hope to join you live to moderate session 4, and in the meantime wish you very fruitful deliberations. Thank you very much.
Thank you very much, Ms. Lee Yong-jie and Ms. Anna Jobin-Brett, for giving the opening remarks. Now it comes to our first session of the day. Session 1 will focus on overcoming challenges to the use of mediation in ISDS.
Good afternoon, good morning, good evening to everyone. Let me offer, as the chair of Working Group 3, my thanks to UNCITRAL, the Secretariat, for organizing this session today, and of course to the People's Republic of China and to Hong Kong for the assistance and the smooth presentation so far. The Working Group is very grateful. And let me thank everyone as well for their flexibility in attending this virtual session. As our distinguished secretary, Madame Jobin-Brett, said, our first ever pre-intersessional meeting, as we hope and find means to advance our work during the current difficult and awful circumstances of the worldwide pandemic. Fortunately for me, I don't need to go into much background today. We've had a nice introduction, especially as to the work of Working Group 3 by our distinguished secretary. As she noted, we most recently considered the topic of mediation and other forms of alternative dispute resolution at our virtual meetings held just several weeks ago. There was indeed, as our distinguished secretary said, a shared desire amongst delegates to develop more specific work on mediation and other forms of alternative dispute resolution for the working group's further consideration. And I would say it was recognized that there are disputes that are now going to arbitration, which is a legally adversarial process, a process that is contentious and which often tends to damage or even destroy the relationship between an investor and a state. And there was a feeling that, in fact, many such disputes, not all, but many, could perhaps better be resolved through mediation, or other non-adversarial processes, which in fact can work to preserve and even build the relationship of trust between an investor and a state, which is necessary for that relationship to be successful. And so, as was noted already today, one of the major questions that the working group discussed was why. Mediation, conciliation, other forms of non-adversarial dispute resolution exist. They are successfully used in commercial disputes, and they have been for a long time. They're certainly not prohibited from use in the ISDS context. And in fact, there are rules that exist already that are there to facilitate their use. And ICSID has some of those rules. Other institutions do as well. But there are rules already. And yet, these forms of dispute resolution are still rare in the ISDS context. Some of the reasons for that are highlighted in the background paper that was prepared and distributed for this session. And our panelists today will identify some more, as well as try to look beyond just the concerns, but look towards, in fact, potential solutions as to how they might be more favorably resolve these concerns so that we can move towards more mediation. I would say one of the factors that was emphasized at the working group and that we did hear already today was a unique feature of ISDS in that it occurs in the context of governments making decisions. And that context itself affects who is making the decisions, one department, many departments, how those decisions are made, how they are relayed, what motivates decision makers in governments, among other factors. You have heard from our distinguished Secretary, Madame Joubert-Plette, the many tasks that as a working group we have assigned to the Secretariat in this area. I do not need to repeat them. There are a lot. The working group is developing a work plan, which hopefully will be discussed in the intersessional period and agreed in the intersessional period to see how we accomplish these tasks. But I would say here, with respect to mediation, we are at the beginning of our work of trying to tackle this. And at this pre-intersessional, I hope to hear about some of the best practices of states and practitioners, about how they conceptualize and view some of the concerns that exist with respect to these tools and their ideas on how we might start efforts at increasing the use, where appropriate, of mediation and other forms of alternative dispute resolution. And with that, let me introduce the first panel of the day. I'm not going to spend a lot of time doing this. I believe the biographies are available in the electronic program, and many of these people are well known to all of us as it is. First, we have Justin D'Agostino, who is a partner at Herbert Smith, who is actually joining us in person in Hong Kong. We can see him on the screen there. He will be our one in-person presenter today. Much to my own personal chagrin, because I had been very much looking forward to this visit to Hong Kong. And when it came up in my calendar as a reminder a few weeks ago, it was with a fair degree of sadness that I saw it, because I knew I would not be traveling and instead would be doing this virtually. Justin will be offering us the practitioner's perspective on how we can overcome some of the obstacles that have been noted and increase the use of mediation in ISDS. We will then turn to Meg Kinnear, the Secretary General of ICSID, and my first boss in the Government of Canada, who has, and I would point out, Ms. Kinnear has just been elected to her third term. So congratulations to her as the Secretary General of ICSID into the future. She is going to give us the institutional perspective, and will address some of the innovations that have been taking place at ICSID and what they are doing to increase the use of mediation and alternative dispute resolution there, including work that is ongoing on some new rules for mediation that we have been developing at the member states of ICSID. We will then turn to Professor Jae-Min Lee, who is a professor at Seoul University and who attends Working Group 3 and has other working groups as well, but we have the pleasure of having Jae-min in Working Group 3 as the distinguished delegate for the Republic of Korea. Jae-min will give us the state perspective and the experience of the Republic of Korea in terms of dispute resolution and prevention using mediation in ISDS. And so we'll be able to offer us some valuable on-the-ground experience. And finally, we will turn to Mare Uran Bidigan, who is the coordinator for the Foreign Investment Arbitration Defense Program for Chile, and is also the distinguished delegate from the working group. She represents Chile at Working Group 3. Mare will talk in more depth about some of what we have been discussing in the working group, and in particular the tools and how a multilateral instrument might be developed and could be used to further encourage mediation in ISDS. I would encourage, if you have questions, that you can post them in the chat. And if I can figure it out, I will be able to read them and we will try and discuss them and assign them and respond at the very end. The way this will work, as this session anyways, is we will transition from speaker to speaker. And our wonderful folks in Hong Kong will help us technologically with that. I won't come back and intervene in the middle. We will go straight to speaker. And because I won't be intervening, I urge speakers now to remain on time. We have 15 minutes per speaker. I do have my gavel around somewhere, and I will bang it ferociously if you are late, but you won't be able to hear me because my microphone will be off. So I urge you please to try and stay on time yourselves so that we can get through and have some time for questions. And remind you that it is always the first panel of the day that if they go long means everybody ends up staying longer at the end of the day as well. So it falls to us to have that responsibility. And with that, let me open the first session and ask Justin to take the floor.
Thank you very much, Shane. Secretary for Justice, ladies and gentlemen, good morning from Hong Kong. As you heard, I'm here in person, and I'm very sorry that those of you who are joining us virtually are not here in person, because you would have had the pleasure of being in this splendid historic building, which has just been renovated as part of Hong Kong's new legal hub, and it truly is spectacular. So I do hope that you get to join us here in Hong Kong in person very soon. But we do have some people in the room here today, so I'm not speaking in a complete echo chamber, so I'm not too lonely. But a very good morning from here. And we're here to discuss today how we overcome challenges to the greater use of mediation in ISDS. And I've been asked for the next 15 minutes to tackle this topic from the perspective of the practitioner. Now, I've been aided in this task by an excellent and comprehensive discussion paper, which was prepared by Adrian Lai and Matthew Sewan for this session, and thank you both to them. Their paper, as well as identifying the obstacles, has some very useful and interesting history leading to the present discussion on the need for reform to the ISDS system, including to encourage greater use of mediation. So my brief remarks are going to draw on my own experience advising both investors and advising states on the resolution of investment disputes. So I'm going to endeavor to be fair to both sides in identifying the obstacles to the greater use of mediation. And to give some further context for our discussion this morning, I want to highlight a few data points from the latest ICSID caseload statistics. And I think this really is important context for the discussion this morning and today. Now, the donut that you see on this slide shows a breakdown of all cases registered at ICSID from 1966 to the end of 2019. And of the 745 cases in total, only 12, that's just 1.5%, were referred to conciliation. Now, a new conciliation request, we understand, was registered this year. So as of today, there are 13 cases. Now that is, on any view, a very small number. Now conciliation is not, of course, exactly the same as mediation, but I think for present purposes we can agree that it's a close cousin. This slide shows the outcomes in those conciliation proceedings. So of the 12 that I mentioned to the end of 2019, this slide shows the outcomes. And as you can see, the parties only reached an agreement in 11% of those cases. So if you're doing the maths and you're nimble, because there were only 12 conciliation cases in total, and a number were discontinued before a final report was issued, this means that only one of those conciliation cases resulted in an agreement. On any view, a very small number. Now, this donut shows the outcomes in ICSID arbitration proceedings, and it's a busy slide, but let me draw out a couple of things. I think we can interpret from this slide that these statistics imply an overall settlement rate of around 20%. Now, that's not insignificant. And the United Nations Conference on Trade and Development, UNCTAD, has also calculated an overall settlement rate of about 21% in cases referred to arbitration, including ad hoc cases and other institutions. But these overall settlement rates are much lower than you would see in comparison with, for example, commercial disputes in litigation. One example, over the last 3 years, the settlement rate in English commercial court litigation has been around 60%, 60. Now, at least part of the disparity in settlement rates can no doubt be explained by some of the factors which have been identified as obstacles to mediation in ISDS. In other words, there are features of the ISDS system which make reaching settlements more challenging, whether that's through direct negotiations or mediation, but it is more challenging for sure. So with that context, the small number of settlements that we see in ISDS cases, let's now start at the beginning of the dispute. Now, discussion about ISDS, discussion about ISDS tends to focus on claims under investment treaties, under the treaties. But at ICSID, 16% of cases are based on investment contracts and 8% on the investment law of the host state. So that means that in about a quarter of all cases, the state's consent to arbitrate arises from a contract or from a domestic law, not necessarily from the treaty. And I think this is important because if states wish to encourage mediation or even to make it mandatory, the provisions of investment contracts and domestic law are, it seems to me, low-hanging fruit for reformers. We don't just need to be thinking about the treaties. Those investment laws or investment contracts or domestic laws would, I think, be easier to change in the short term to achieve consensus with than trying to achieve consensus with other states on the approach to take in treaties. So we do have some low-hanging fruit, which I think is worthy of attention. Turning to treaties themselves, as the discussion paper mentions, a common approach in investment treaties over the last few decades has been to impose a cooling off period. A cooling off period typically of between 3 to 6 months before the investor may refer a dispute to arbitration. And people will be very familiar, of course, with these cooling off periods, but here's an example from the 2008 UK model BIT. Now, there's been significant debate as to whether such cooling off periods are mandatory. And that debate extends to whether a tribunal may decline to exercise jurisdiction if the claimant has not complied strictly with that cooling off period. I'm not going to wade into that debate today, which in any event turns on the particular language in the treaty itself. But instead, I wish to offer some preliminary observations from practice. In my experience, almost always, the case is that the claimant investor will send a notice to trigger the cooling off period. They tend to seek to comply. In a minority of cases, the investor may seek to commence arbitration without issuing such a notice or before the cooling off period is expired. And my experience has been that this is typically only in cases where there are circumstances of exceptional urgency, meaning that the investor feels it cannot wait. In those cases, it seems doubtful that a mandatory requirement to cool off in cases where there's extreme urgency is likely to increase the prospects of a mediated settlement early in a dispute, and more likely that the investor will look for other remedies. But in cases where there's no urgency, as I've said, the investor will typically send a notice. Often at that stage, it's accompanied in parallel with an invitation to the host state to negotiate. Sometimes this invitation to negotiate is in order to comply with a specific provision, which indicates expressly that the cooling off period is to be used for consultations or for negotiations. But in my experience, I think it's also fair to say that the majority of claimant investors would be more than willing to negotiate with the host state if the state was also willing. But speaking from experience, it remains quite rare for a host state to accept the investor's invitation to negotiate at this stage. Indeed, it's not uncommon for the host state to completely ignore the notice until the investor has filed the request for arbitration. Now, there's a number of reasons why states may be reluctant or less likely to engage in negotiations at this stage. Some of the reasons are set out in the discussion paper. For example, the relationship with the investor is already very strained at this stage. Some officials may have a desire to defer responsibility for a decision-making party to a third party. May defer responsibility for a decision to a third party rather than taking the decision themselves. There may also be obstacles at this stage to coordination within the host state between different ministries or departments with interest in the dispute. To that list, I would add a few other examples. First, the dispute may have no urgency for the host state. Indeed, like many respondents, the host state may perceive that there's a strategic advantage to delaying resolution of the dispute. And I'd pause briefly to note that a desire to cause delay is not incompatible with agreeing to mediate. That's because, of course, engaging in mediation may take some considerable time itself and may therefore serve to delay the commencement of arbitration. Secondly, I would add that governments are often not able to make decisions as quickly as corporates. This may limit the prospects for using mediation or other forms of ADR expeditiously, and certainly at the outset of the case. Thirdly, most host states are not repeat litigants. They're not repeat litigants in ISDS proceedings, that's for sure, and therefore may not automatically appreciate the inherent advantages of mediation. So there is education to do, and I'll come back to that. But the appreciation of the inherent advantages of mediation, including to narrow the scope of the issues in dispute, even if it doesn't result in a settlement, are not widely known. Last but by no means least, I would add to the list that the fact at the very early stages of a case, it may be very difficult to predict its eventual outcome, and therefore difficult to make decisions on parameters for settlement, can also put off engagement. In my experience, this last point is actually very important in thinking about how to encourage more frequent use of mediation in ISDS. Critically, we should ensure that we're not only thinking about the increasing use of mediation at the outset of a dispute, or thinking about mediation exclusively. Earlier in my presentation, I referred to the 60% settlement rate in the English Commercial Court. A significant number of those cases are only settled on the metaphorical court steps, on the metaphorical courthouse steps. This suggests that the prospect of a binding third-party decision, if the parties cannot reach agreement itself, is a critical ingredient in encouraging settlement. Domestic law may also incentivize mediation and settlement in other ways. It's common, for example, in commercial disputes for parties to make settlement offers which were without prejudice, save as to costs. This means that the offer cannot be referred to during any arbitration or court proceedings, but may be referred to when it comes to the question of costs. In some jurisdictions, civil procedure rules specify the cost consequences of such offers. Essentially, a party who rejects an offer and then fails to recover more than the offer is liable to be ordered to pay the other party's costs. And it's become pretty standard practice in international or commercial arbitration for tribunals to take into account such offers when awarding costs. But it's not necessarily the case that an ISDS tribunal would not take such an offer into account, but it's certainly less common than in the context of commercial cases. Further, ISDS tribunals are less likely, generally speaking, to award costs on the costs follow the event basis compared with the practice in international commercial arbitration. And the consequence in practice is that making a settlement offer in ISDS cases may not offer the same costs protection as we would expect in commercial cases. In my view, this also creates an obstacle, not insurmountable, but an obstacle nevertheless, to negotiated or mediated settlements, because it removes a key incentive for parties to make reasonable offers. I would end with the observation that there are probably also some psychological obstacles to mediation in the ISDS context, born partly because of the fact that it remains very rare. Discussions such as this today, meetings such as this today, save to build awareness of the potential of mediation, and many of the organisers of the conference have also been involved in a very innovative programme to build the awareness and capacity to state officials. In order to see more frequent use of mediation, we also need to build confidence in the process and learning, which means convincing both investors and governments of the fairness and other advantages of the process. I'm looking forward to hearing what my co-panelists and everyone else has to say today. Thank you very much indeed.
Thank you. I am delighted to be here today, and I would also like to thank Adrian and Matthew for their wonderful background paper. I also have a PowerPoint, and if I would like to share the screen with you if I have the technical capacity. There we go. So I have been asked to speak to the ICSID perspective on mediation of investment disputes. And I think it's fair to say that from a policy perspective, the ICSID drafters started from the beginning trying to have the tools most suited to resolve the dispute. And interestingly, they first offered arbitration and conciliation, but the delegates were quite convinced, in fact, that conciliation would be the tool that was inevitably used. Over time, in 1978, another ADR mechanism was added to the ICSID rules, and that was the fact-finding rules. But as Justin has noted, we have had only 13 conciliations in the more than 50 years of ICSID, and no fact findings. So for some reason, and I think there are a number of reasons we can talk about, arbitration has been the dispute settlement mechanism of choice. That said, our policy view is that we would like to continue offering ADR and other mechanisms, and to give parties much greater options to get the right dispute settlement mechanism for their dispute. And so in our most recent amendment process, as Shane has said, we have been looking at new sets of rules. And in particular, we have, first of all, updated the arbitration rules, but we have updated the conciliation rules to make them much more of a modern ADR and flexible type of process. We have updated the fact-finding rules to make those self-standing and, again, a more user-friendly type of process. And most importantly for today, we have put forward a set of standalone new mediation rules. And that's what I'd like to address. Why do that? I think it's evident that there is a lot of interest right now in mediation, and a lot of disputing parties would like to have access to investor state mediation rules. And so that was one of the reasons we decided the time was right. Our view here is that it's very important to give the parties broad access to these rules, and that we're able to provide them an impartial and trusted forum to engage in the kind of facilitated negotiation that you would have in a mediation. So we believe that these are going to be a very advantageous set of rules, and hopefully just the existence and knowledge about these rules is going to help incentivize parties to use them. Now, one of the things we keep saying is that these allow broad access, and I wanted to focus on two things in particular with respect to broad access. The first, of course, is that these are consent-based. So they are entirely voluntary, and you do not need to mediate unless, and in fact, you can't mediate unless both parties agree to mediation. We need mediation consent at the start, obviously at the outset, as you would find in a usual arbitration, and it has to be there throughout the whole process. So as a result, either party can unilaterally withdraw their consent to mediation at any time during the mediation process. In order to encourage access to these rules, we've given two ways to consent to use of the mediation rules. The first is the method that I think we're all most familiar with in the arbitration context, and that is that you have a clause in your investment instrument, either your treaty, your contract, or your law, saying that you agree to follow a mediation process and you agree to the mediation rules. So that is fairly simple and one that we're all very familiar with. However, as Justin said, there are not a lot of treaties at this point, and the treaties still represent about 75% of the work. There are not a lot of them that do have these mediation offers. And so we thought, how is it that we can make it immediately available? And what we came up with was another way to consent to mediation in these rules, and that's consent absent prior party agreement. And essentially what this provision says, if you don't have an option to mediate in your investment treaty or contract, what you can do is have one party request mediation and include an offer to mediate. That will be sent by the Secretary General to the other party, and the other party is given 60 days to accept the offer to mediate. So essentially you crystallize consent at that point under this mechanism of consent. Now, if the other party refuses consent or fails to accept, then no further action is taken on the mediation. But at least it gives another option now, even without these specific forum clauses, to use the ICSID mediation rules. So that is one way we were trying to encourage or incentivize broad use of these rules. The other reason that I say we are encouraging broad access is because these are self-standing, and in particular, the scope of these rules, in other words, the jurisdiction to use these rules, is really quite open. The only thing that is required here is that there is an investment, that it involves a state or a regional economic integration organization, and that the parties consent in writing to using the mediation rules. So you don't have a lot of the very technical difficulties or if I can say hurdles that you have in a regular arbitration, where you have to fit into the jurisdiction of ICSID Article 25, that it is something directly related or directly arising out of an investment involving an ICSID member state and a national of another ICSID member state. What this means most importantly is that this is available to both states and investors who are from countries that are not ICSID members. Again, hopefully allowing a lot more access and a lot easier access for the parties. In terms of the process, I will not take you through step by step, but there are several things that I would like to draw your attention to, in particular, several aspects of the mediation process that make it specific to investor state. First of all, we have a requirement for a request, but it is a very light screening process. So it is not the kind of screening process you might be used to in arbitration, and that stems from the much more easily or much simplified scope provision that I've just talked about. The rules have a preference for a sole mediator, and in fact, that's the default position. But if the parties would like co-mediators, 2 mediators, then that is something that they are able to opt into. It starts with a very short statement of facts and a statement of positions and any agreements that the parties have. And then you go to a meeting with the arbitrator, and together you pull together what's called the mediation protocol, which is essentially the rules of how you go along into this mediation process. One of the things that I think is very important, and this is something we heard back from people who've done mediations, is that we required each party to identify somebody at the first session who would have authority to settle the case and who could describe to the mediators how they would implement a settlement. And you can see that the obvious reason for that is to make sure that the parties are very much committed to the process, involved in the process, and can see the mediator in action. So we thought that that was very, very useful. After that mediation protocol comes together, you go through the mediation, and of course you can use all of the classic tools we talk about in mediation, things like caucusing with one party or the other separately, coming back, having other meetings, those kinds of tools. In terms of costs, we decided that it would be appropriate to have the parties bear the costs equally unless they agreed otherwise. Again, the idea being that you didn't want to get discussion about costs in the way of actually trying mediation. A next issue that's been one for discussion has been the whole question of confidentiality. And obviously everyone in this room is familiar with discussions about confidentiality and transparency in investor-state arbitration. What the mediation rules do is that they propose essentially that all of the information in the mediation and all of the documents generated in that process shall be kept confidential unless the parties agree otherwise, or the information is independently available, or disclosure is required by law. So you can see that there is a preference in these rules for confidentiality of the process. That said, the rules also say that the fact of mediating will de facto be available unless the parties agree otherwise. So at least that much information under these rules should usually be available to the public. So it is a bit of a compromise between 100% confidentiality and 100% transparency, but it certainly does lean to confidentiality and confidentiality of the process. The other important provision, which is in Rule 11, is that any position taken, admissions made, or offers of settlement made, or views expressed by either party during the mediation or by a mediator is without prejudice to the legal positions that they may take later on in any other process. And this is one of the very basics. Obviously, parties would be quite loath to even start into a mediation and to have a frank and open mediation when they felt it might come back to bite them if they were not able to ultimately resolve the whole matter through the mediation. So that is a standard clause, but obviously a very important one to incentivize the use of mediation. The final thing that we thought was extremely important was to make sure that any mediated resolution was going to be enforceable. And so we've come up basically with two potential mechanisms here. First of all, if the mediation is corollary to an ongoing arbitration, then you're able to use the usual ICSID rule that says the parties can have the settlement put into an award, and that award then benefits from all of the ICSID enforcement regime. So that is one way through which parties might ensure that their mediated resolution will be readily enforceable. The other thing that was important for us was that we aligned the mediation rules with the formal requirements in Article 4 of the Singapore Convention. So essentially that the settlement needs to be in writing and signed by the parties, and that there is evidence that the settlement agreement resulted from mediation, as that is defined by the Singapore Convention. So if you resolve the case under these mediation rules, we think it's quite clear that you would be able to enforce in accordance with the Singapore Convention. And I think that is something that's also going to provide quite a bit of comfort to the parties. So that is a quick walk through the mediation rules. I think, as Justin has also said, it's extraordinarily important not just to have rules that we can all use, but at this point to get ourselves familiar with the process and to be comfortable with the process so that parties will be inclined to use them. And as a result, we have been doing a huge amount of technical assistance, courses, those kinds of situations so that parties are getting to know this. We've done a number of mediation trainings, both for mediators and for government officials. We have done a lot of work on the dispute prevention and management, and we've got a huge amount of information that we've made available to parties. So all of this is an effort to make sure that parties feel comfortable with mediation. That said, I wanted to make a few final points, and they may seem evident to you, but I think they are important. And the first is that it's extremely important to develop an internal awareness about mediation and a party's capacity to mediate. You obviously do not want to be in the situation where you receive a request for arbitration and all of a sudden say to your clients or to in-house government officials, let's mediate. And they're saying, what are you really even talking about here? So knowing about mediation and having an openness to it and having at least some idea of when you're going to be willing to mediate and when you might just say, that's not the process we choose to follow, is very, very important. And I think in this respect, it's really important to remember mediation and these mediation rules are not just available or are not just conceived for the cooling off period. Our thought is that these are rules that are available throughout the entire process, that they may well be used standalone, or they could be used in parallel to another dispute resolution. The one you might think of most often is arbitration with mediation beside. They can also be used at any stage in the process. So I think starting to become a bit creative about this and saying, well, you know, we might not have decided on mediation at the beginning, but now we're starting to understand our case better. Let's try a mediation. That's the kind of thinking that we need to start getting comfortable with around these rules. The next big point is one that we've often made in the context of arbitration, but you must get your internal framework basically ready. So who is the lead agency? Are there any domestic law concerns that need to be addressed? Can state officials mediate and ultimately resolve the dispute? Are there any particular permissions required? Are there any particular authorizations required? And if part of your mediated settlement included pecuniary relief, how do you get that paid? So having that internal framework ready is key. The final one that I also wanted to note is the whole issue of communications. No government wants to be in the position of being portrayed as compromising or implicitly saying that they are liable, but being tied to that kind of a communications message. And what I think is extremely important, and I've seen done very effectively, is that any kind of resolution can be tied to why you're doing investor state in the first place, which is that you have managed to attract, or more importantly in this situation, to retain or even expand FDI in your jurisdiction. So those are some final points I'd like to make. And with that, my remarks are concluded. Thank you.
Hi, good morning, good afternoon, and good evening, everybody. Thank you, Shane. Let me also share my PowerPoint slides. Let me try. I'm waiting for the slides to be stopped. Okay. Here we go. Again, thank you. I'd like to thank UNCITRAL and Department of Justice of Hong Kong Special Administrative Region and Asian Academy of International Law. I'll just follow up on with what Madam Secretary General Kenya just mentioned, and also what Justin mentioned as well. Largely, I'll talk about basically why mediation could be effective in investment dispute settlement mechanism, and why it could actually address some of the concerns identified during our discussion at the UNCITRAL Working Group 3, and how we could do better in making this system work more efficiently than before. I'll just talk about experience of Korea from time to time, but I believe the experience of Korea could be equally applicable to other countries because the application of mediation is still in the very early stage, and I would say very skeletal, and in the development stage as well. So that's why many countries have interest in this particular topic. Now, well, in fact, mediation is in increasing demand in other segments of international dispute settlements proceedings as well. Commercial arbitration, as mentioned by Secretary General Kenya and Justin, Singapore Convention provides a good momentum for the facilitation of the utilization of mediation in commercial disputes, and benefits of mediation is well known. And most importantly, state-to-state dispute settlement mechanisms are also paying attention to the effectiveness of non-binding dispute settlement mechanism as well, be it WTO or be it FTA. With respect to Korea, Korea is relying on non-binding dispute settlement mechanism for certain disputes in their own FTAs for state-to-state disputes. For instance, Korea has non-binding dispute settlement mechanism in the name of mediation with the EU to deal with non-tariff barrier dispute issues, and with China as well. And with the United States, it has a mediation procedure for automobile sector issues. So increasingly, even states are relying upon the effectiveness of mediation. So perhaps we could also think about utilizing mediation in the context of the controversial and very complex investment disputes as well. As explained by Shane in the start of our panel, Working Group 3 discussion is already talking about mediation and largely dispute prevention and mitigation and ADRs generally. In particular, Working Group 3 discussion is focusing on mediation. And also, I believe many states are paying close attention to the development, very timely development of ICSID, as just explained by Madam Secretary, with respect to the new rule, most recently updated in February 2020. So all these things provide us, the states, and investors as well, a timely opportunity to talk about mediation now seriously, and how mediation can be effectively and robustly applied in the context of investment settlement proceedings. As explained by Justin, it's also very interesting to note that conciliation has been utilized only for 13 instances for the long history of ICSID. So it makes us pause to think about what we could do better and what we could think about differently in this respect. Now, I think the most important thing when we consider mediation in the context of investment disputes is about the uniqueness of mediation in maintaining and preserving the long-term relationship. Many times in the investment dispute context, for instance, with respect to the experience of Korea, investment arbitration usually leads to, I will not say termination, but very difficult relationship between host state governments and foreign investors, which may foster which may make the environment of the whole investment disputes very contentious and very difficult to resolve, even after an award is rendered by a tribunal. So that's why I think the uniqueness of mediation in preserving long-term relationship and valuing long-term relationship and trying to find a common ground between investor and host state is very important factor that we should consider in the context of investment arbitration and mediation here. Also, it appears that having a mediator is very important. Well, it's one thing for us to say that try to find an amicable resolution. In fact, almost all IIAs have a particular provision saying consultation, reconciliation, and mediation are always available. And we allow and we foster parties, we encourage parties to rely upon those proceedings. But in fact, it's really difficult for states to rely upon these proceedings because there's just one single statement, a short statement in the IIAs without much details on how to proceed with the mediation. I think that's one fundamental problem. And I think that's why the development in ICSID or the recent development in other IIAs, including CETA, where detailed provisions of mediation is now finally being discussed. I think that's a very important development because that now provides the states a really practical opportunity to consider mediation seriously in addition to or in lieu of arbitration. So that's something that we can consider in discussing mediation in the investment dispute context. Well, with respect to the Korea's experience, well, I'm just speaking for myself today, but it seems, as far as I understand, it seems at least to countries like Korea, it's difficult unless we have a specific provisions in IIA, unless we have a specific framework in IIAs or other multinational international instrument wherein mediation is arguably one viable option in parallel with arbitration. It's really difficult for a government official to go ahead with a amicable resolution in the context of mediation because, again, as just mentioned, the responsibility the practical responsibility, sometimes the legal responsibility would fall on the shoulder of the decision maker of the government. So that's why I think having a framework and detailed provisions in mediation is important in many respects. Now, a couple of challenges to consider. I have already mentioned some of the challenges. The first thing is the last one, responsibility issue. From the perspective of the government officials, it's really difficult for any government official to decide on mediation. It's one thing for him or her to continue with arbitration and encounter the final arbitral award, whatever it is, whatever it may be. But it would be quite another for him or her to say, this is it, I'll make the decision and mediation is the final solution for this dispute. I'll take care of it. It would be quite difficult for any government official to get to that point. So that's something that we can contemplate on considering these issues. And another one is how to reconcile the increasing trend of underscoring public oversight in the context of transparency with the the inherent trait of mediation, which values confidentiality. I see some of the balancing point, as just explained by Madam Secretary Kenya in Rule 10 of the new mediation rule, wherein we could see the effort to find a balancing point. But again, fundamentally, on the one hand, we try to underscore the transparency issue in the larger context of ISDS reform, but on the other hand, the mediation is based upon the strong or strict confidentiality rules. How to reconcile it? That's another question mark that we could consider. And the third one from the bottom is how to deal with the cost and duration, because again, it could be used as a delaying tactic. Sometimes it could be used as a delaying tactic from time to time. So how to find or how to safeguard good faith mediation from those delaying tactics. That is another issue. And the fourth one from the bottom is how to coordinate the mediation with the existing system of arbitration. If we include mediation in the context of ISDS mechanism generally, then we have to think about the relationship between mediation and arbitration. Should mediation be a mandatory option or just a voluntary option as we have today? Should it be a alternative, or should it be a way station going to the arbitration, etc.? That is something we could also consider in formulating the texts of mediation in the future IIAs or multilateral international convention as well. And finally, the key question is flexibility and due process issue. Well, mediation, the beauty of mediation lies in its flexibility. And in mediation, even ex parte communication is permitted. So the mediator can freely talk to one party or sometimes two parties, and the mediator has the obligation not to disclose what he or she has heard from one party to the other party. So a mediator has the full trust of the two parties in resolving the disputes, even if he or she cannot impose the binding resolution outcome on the parties, but still he enjoys the full trust and confidence from the two parties. That's the beauty of mediation with the flexibility. But at the same time, how do we select a mediator, or how do we oversee mediator? How do we preserve the core elements of due process? That's another issue. I also see the CETA agreement and the new mediation rule of ICSID providing detailed provisions of a code of ethics of mediators. So that's one good starting point for this discussion as well. And now, finally, some thought on how to overcome or try to overcome those challenges. As mentioned, I think the first point that we should contemplate should be elaboration. It really, I think, just providing a brief statement of the possibility of mediation is not enough to have mediation be adopted in practical terms by government officials and government agencies and investors. So we should try to, the states and the stakeholders should try to contemplate how to elaborate existing provision on mediation in a way that provide a detailed guidelines on mediation, so that the states and investors could adopt mediation as an effective alternative to the existing dispute settlement mechanism of arbitration. So elaboration is the starting point. And again, ICSID effort, new mediation rules in ICSID is a good benchmark for other discussions and working group 3 discussions as well. And at the same time, the systematization, not just mediation alone, but how to understand mediation in the overall context of ADR for settling investment disputes and arbitration. What is the relationship between mediation and cooling off period? What is the relationship between the arbitration and mediation? And also, if when we look at mediation provisions these days, there's one short statement of the possibility of mediation. And then usually we can find a statement that mediation can be initiated at any time of the proceeding, which could be understood as before arbitration, even during arbitration, or perhaps even after arbitration, to deal with how to enforce or to how to find the best way to enforce the arbitral award. So it's not clear how to understand the mediation in the larger context of arbitration. So that's something we can also think about in the overall context of systematization of investment settlement mechanism in the ISDS system, generally in IIAs. And how to safeguard the legitimacy issue. Again, the mediator, how to oversee, or perhaps not to oversee the mediator, the code of ethics. Perhaps we could include roster of mediators in IIAs or multinational instrument as well, and also how to ensure at least minimum level of transparency. Again, finding a balance. Confidentiality is essential for mediation. But at the same time, the argument for ISDS improvement / reform lies in how to increase public awareness, public oversight, or transparency, how to find a balancing point. Perhaps some minimum elements of mediation, such as the fact that mediation is taking place and what are the elements of issues being disputed. Those issues could be conveyed to the public oversight if possible. So that's something we could contemplate. And finally, how to enhance practical availability. Perhaps I think investors and government agencies, they might have strong interest in pursuing mediation because it's cost efficient and it's time efficient, and most importantly, it helped them preserve long-term relationship. So they have strong interest in mediation. The question mark is it really practical? Is it really practically available for decision makers of the government, or for that matter, decision makers of the investors or investing companies? Is it really practical alternative? That's something that we should contemplate in discussing this issue down the road. That's it for now. Thank you. I'll stop here. Thank you.
Thank you. Good morning, afternoon, and evening to all. I would like to start by congratulating the Asian Academy of International Law, as well as the Department of Justice of the Government of Hong Kong, SAR, and UNCITRAL for the outstanding organization of this event. I was requested to explore with you today whether a multilateral instrument on ISDS reform could encourage the use of mediation. Now, give me just a second because I don't seem to be able to move my presentation. Apologies. Sorry, so I was requested to explore with you today whether a multilateral instrument on ISDS reform could encourage the use of mediation. But in order to delve into this topic, I would like to take a step back and give some context to our audience, which I understand includes not only working group delegates, but also members of the general public. So to do this, I propose to proceed as follows. First, I'll invite you to remember and mention very briefly some of the issues that we discussed a month ago at the 39th session of Working Group 3, which was already mentioned by our Secretary General, Yuan Brett, a few minutes ago. The second part of my presentation will be devoted to explaining why a multilateral instrument on ISDS reform has been perceived by a number of states as a reform option on itself and an implementation mechanism for many of the other reform options, including mediation, that merits the working group's attention going forward. And third, I'll explore if indeed such an instrument could be of assistance to overcome the challenges that mediation has faced, and in short, whether such an instrument could be a means to encourage the use of mediation. Now, let me start with a summary of the discussion held a month ago. I'm not going to go through each of the points that are on the slides, as some were already mentioned by Secretary General Jovan Brett, but I'll mention the remaining ones. And in particular, the need to set up a legal framework to encourage mediation and the need to set up policies providing legal certainty for the use of mediation was an aspect touched and discussed by the working group a month ago. Delegates in the group also emphasized that not all disputes are suitable for mediation, and any future work on this topic should ensure that application of ADR methods would not lead to unintended consequences such as regulatory chill or reduced transparency. In this sense, the working group did mention that public interest shall also be represented in the mediation process. At the end of the session, and as the Secretary General mentioned, the working group requested the Secretariat to prepare guidelines and best practices on ISDS mediation, and also to work with interested organizations such as ICSID to develop or adapt rules for mediation in the ISDS context, as well as model clauses that could be used in investment treaties, but also in a potential multilateral instrument on ISDS reform. Now, why a multilateral instrument on ISDS reform? Why could this be, and I apologize for the noise, why could this be an appropriate implementation option? The reasons are multiple, but I will try to explain in particular for the members of the audience who have not had a chance to participate in working group's discussion, what we refer to when we're talking about a multilateral instrument on ISDS reform, and why we believe this could be a good implementation option. Now first, after the last few years of discussion at UNCITRAL, it has become clear that states not only have different interests and may face different concerns, but that even when they share the same concerns, they may not be in a position to implement the same solution at the same time. It has also become evident that a reform process will only be successful if there's buy-in of the process by a significant number of states. And to attain the widest possible participation of states in reform ISDS, we need to provide a flexible framework that allows different reform tools or solutions to be pursued and implemented independently from one another. After 3 years of discussions and having reached the third stage of the process, Chile and a number of other delegations believe that the time has come to have some certainty as to the mechanism through which we would implement the hard-fought consensus reached at Working Group 3. The right implementation mechanism could be to integrate the various procedural solutions developed by the working group into a multilateral, legally binding treaty, not only for the reasons described before, but also because a flexible multilateral instrument would allow states to benefit from solutions when they are ripe, without needing to wait for all solutions to be fully developed before we can implement any of the reform options, including ISDS mediation. In addition, the instrument could contribute to achieve uniformity of the applicable procedural rules, and thus consistency and coherence of the investment regime as a whole. And last but not least, developing and elaborating a multilateral instrument could be a very effective mechanism for countries to efficiently and effectively update their network of older style international investment treaties with modern procedural provisions. This could go a long way in modifying the current ISDS system. Having now given you some context on why we are discussing the idea of a multilateral instrument, let's explore whether such an instrument could indeed encourage the use of mediation. And to do this, I propose to begin the analysis with the challenges that are most commonly cited as an obstacle for the wide use of mediation, to then determine if and to what extent a multilateral instrument could assist to overcome those challenges. Many have already been mentioned by Justin, referring to the very useful background paper prepared for this pre-intersessional meeting. Others were mentioned by Meg and Jamie. They are listed on the screen for ease of reference, and it is in that order that I will proceed to examine them. Now, as Jamie mentioned a few minutes ago, we today have a situation in which even if parties to an investor-state dispute would like to resort to mediation, chances are that they lack the appropriate basis to do so. Therefore, one of the first challenges for ISDS mediation to be used in a wider scale is the lack of a proper and effective legal framework. While there are a rising number of international investment agreements in which consensual mediation has been included as part of the dispute resolution process, this is not the case for the majority of investment treaties in force today. Thus, incorporating mediation in a multilateral instrument on ISDS reform through a mediation chapter or protocol drafted on the basis of best practices, considering, among others, the new ICSID mediation rules and modern IIAs, would not only promote investment mediation moving forward, but it would also be the most efficient way to ensure that mediation is incorporated in hundreds of first-generation treaties that don't include any reference to mediation at this point. Thus, the multilateral instrument would be one of the best options to transform ISDS mediation from talk to action. In addition, the multilateral instrument could put in place a uniform legal framework for ISDS mediation available to all states. Instead of having each state try to include different frameworks with the potential for fragmentation that this could cause, we could have a uniform legal framework. In short, a carefully drafted multilateral mediation legal framework included in the multilateral instrument could indeed foster the use of mediation in the ISDS context. The second challenge commonly cited and was mentioned already today is the state's official unwillingness to assume responsibility for voluntary settlements or preference to defer decision-making responsibility to an arbitral tribunal or to a third party. And this is reasonable and understandable, of course. We've discussed it earlier on, but deciding to use taxpayers' money to settle a claim is no doubt a difficult decision that will always need to be carefully considered and properly justified by any state official. But even if this is the case, in my experience, and perhaps different from Justin's experience, states are more frequent than not willing to engage in a meaningful negotiation process to settle the dispute before a request for arbitration is filed with ICSID. This does not mean that materializing an agreement reached through negotiation or mediation is not a difficult proposition. And incorporating mediation as a mechanism to settle investor-state disputes in a multilateral instrument could assist. Let me explain how. First, its inclusion in a treaty could increase confidence in the process and promote mediation as an adequate means to resolve ISDS disputes. This, in turn, could justify its use in the eyes of state authorities. Second, a state authority may be more willing to accept a mediation if the process is initiated on the basis of a detailed mechanism elaborated and developed following best practices and set forth in a multilateral binding treaty that has been signed and ratified by the states. In other words, the multilateral treaty could become the state official's justification for its decision to use means alternative to arbitration to solve the claim, and he or she could be less exposed to public and political criticism for preferring a mediated agreement over engaging in a long and costly arbitration. The third challenge I will address is what the background paper has called resistance to mandatory mediation. And reflecting on this took me back to the old tension between transparency and confidentiality. And while confidentiality of the mediation process is regularly cited as a potential benefit of this mechanism over other forms of dispute resolution, the potential lack of transparency of the mediation process that this confidentiality entails has also drawn negative attention. And this is because part of the concerns that we seek to address in Working Group 3 relate to the need to have increased legitimacy and accountability of the ISDS system through, among others, increased transparency, a point also mentioned by Damien a few minutes ago. This realization should be considered in conjunction with the general consensus discussed at the last Working Group 3 meeting that not all disputes are suitable for mediation. While some disputes, for example, so those that are contractual in nature and are disguised an investment dispute or subject to umbrella clauses may be well suited for mediation, other cases where important public policy issues are at stake could be less likely good candidates. In this sense, while we could incorporate a clause in the multilateral instrument that seeks to make mediation a mandatory process prior to arbitration, a non-consensual mediation may not be adopted by many states. First, because there's a perception that mediation is not appropriate, and second, because the states would be cautious of adopting a mechanism which could replicate the same concerns that investment arbitration has faced. Thus, while we understand that some of the literature see the lack of mandatory mediation as a concern, we consider that making mediation a mandatory step in the process could run counter the objective of fostering its use. And finally, apart from incorporating mediation in a multilateral instrument, we believe there are some other practical challenges that perhaps a multilateral instrument on ISDS reform will not be able to tackle, and other initiatives will be necessary. In particular, while the question of adopting of when to start the mediation process and whether how the timing of the mediation could assist in making sure that the relationship between the state and the investor has not yet broken out, or making sure that mediation can be used after the arbitration has started. These are questions that can be actually incorporated in a multilateral instrument, but there are others that won't be solved through a treaty. For example, it would be necessary to ensure that policies, rules, and regulations are put in place at the national level. So, and this was already mentioned by Meg a few minutes ago, and it will also be necessary to set forth a strong capacity building mechanism in order to make sure the general public and all the users are actually more aware of mediation. To conclude, while a multilateral instrument on ISDS reform will not be able to address all the challenges, It could be a relevant instrument to implement modern mediation rules at a global scale and foster its use as a prime mechanism for the resolution of disputes between states and investors. And with this, I thank you for your attention and we'll be happy to answer any questions.
Well, thank you to all of our distinguished speakers today. We've gone through a number of topics. We do have a few minutes left in our allotted time. And so perhaps what I can do is we do have some questions that have been raised in the chat. So let me perhaps address a couple of the quicker ones first, and then we will come to a couple of the ones that take more time. So there has been a request to share some of the PowerPoints that were done during these presentations. I assume that this can be done, and it will be done most likely on the website of the UNCITRAL Secretariat at the link, or at least on the link of this particular pre-intersessional. So I would assume that we can handle that. There is what I'm hoping is a quicker question also for our distinguished Secretary General of ICSID. ICSID offers training for mediation, and the question is this training available at discounted rates for developing countries and least developed countries? And so perhaps I can just ask Meg to quickly answer this question as well.
Yeah, you can hear me?
Yes, we can.
Yeah, it's not at discounted rates for any particular category of person, but we're also very happy to create that kind of training in any particular location or remotely. So I think we can easily work out that kind of training without finances being a barrier.
Thank you, Meg. So for any delegates who might be interested in further information on this training, contact the ICSID Secretariat and something can be arranged. In the few minutes we have, I had a number of questions we'll try and get to. This is the first one we received, a question to all the speakers. The dissemination of information related to the use of mediation in ISDS disputes may be useful to encourage disputing parties to give mediation a try. However, mediation usually comes with confidentiality, and it is difficult to locate information on the actual use of mediation in ISDS disputes. What can be done to further promote information dissemination on mediation? This comes to us from Matthew Suen, and it's interesting. It links up a number of factors that have been discussed. We had at the beginning Justin mentioning that there is some psychology preventing the use of mediation. As a government person, I can say that governments are often loath to be groundbreakers. They are naturally conservative, and not seeing one of the first questions you might have with a suggestion to do mediation is, in fact, has it been done before? Who else has done it? Any like-minded states have done it. This gets down to the question of information dissemination. And this has been a topic, it's been raised, I think, by all of our speakers, the balance between transparency and confidentiality. So is there potentially one speaker who wants to address this question? Or I can call on somebody.
Well, I mention a couple of things, Shane. I think one, Meg took us through the new mediation rules, the ICSID rules, which I think are, they're terrific. And I think the balance that they've struck on confidentiality in those rules it was right and encouraging. One thing that hasn't come up in this panel actually is the role of the tribunal in relation to mediation. And just one, in a sort of nutshell, in the commercial context, we're seeing, I think, more proactivity from tribunals in encouraging the use of mediation. And I say that in answer to this question, because when that comes up, if there's no framework for the mediation once the arbitration is commenced. I've seen in many cases the tribunal help the parties to devise a system to ensure that information does flow and that confidentiality is preserved. So maybe not to get into too much detail on it now, Shane, but we didn't really pick up much on the role of the tribunal, and they often do have a very important role, both to encourage the use of mediation and to facilitate it once the parties have agreed to use it.
Thanks, Justin. That comes to, of course, something else that's been talked about in transparency in ISDS a lot, which is the role of the tribunal in ensuring the dissemination of information, but the appropriate protection of confidentiality. And one of the things Justin is pointing out is, at least where a tribunal has been formed already, the tribunal could play similar roles in that sense. I have a number of other questions we'll try to get to. I've got two from Adrian Lai, who is one of the people who did the background paper. Let me go both to them, and perhaps we can get some answers to it. We'll be conscious of time. We may not get to all of the questions, but we will do our best here. So the first was simply following up on what what Jae-min had said, is to what extent would government officials prefer to delegate the determination of politically laced investment disputes viewed to a third party to avoid public backlash? And does such a preference disincentivize states for opting for mediation? And what would be our thoughts on this? And of course, this is a particular concern in the investment context. We noted the context, it is government decision-making. It is also often government decision-making on sensitive policy areas, from environment to natural resource extraction. And so what might be the views or the tools on sort of that psychological incentive on the part of government officials? And I think this was mentioned both by Jae-min, also Mare, you touched on this as well. The second one is a question to Mare as well, which is, can the proposed multilateral investment instrument encompass all kinds of ISDS reform options that have been proposed so far? And what are the implications on the existing investment treaties from an international law perspective? So a little bit outside of the context of mediation specifically. Let's turn to the first one first, and perhaps Jae-min, I'll turn to you first, and then leave it to other people to comment as well if they would like.
Okay, thank you, Shane. Let me try. I think much of the issue or psychological barrier on the part of the government officials, I think much of the barrier relates to perhaps capacity building as well. So I think because we have not had mediation that much in the investment context, I think there's natural psychological barrier, and the capacity building or technical assistance could help address that issue in the longer term. And also the clear guidelines and guidance and detailed provisions about mediation could provide the more predictability and reliability of mediation that could help government officials to think about this option in a more practical way. Thank you.
Thank you, Jae-min. Anybody else want to comment on that? It is a difficult problem, one that relates really to what it is to be a government official sometimes.
Yeah, thank you, Shane. I mean, I think it is true that it's a big responsibility to make a decision to settle a claim. At the same time, it has been my experience that it is also a difficult decision not to settle a claim that can be settled, and make the state have to be involved in a lengthy arbitration process for a very long time. So I believe the hardest part is to assess the real risk that a dispute actually entails, and making sure that you're making the right determination for the state. It has not been my experience that the authorities have been especially reluctant to at least engage in negotiations and really try to find ways of making sure the dispute is settled in the most beneficial way to the state, which many times is the most beneficial way to both parties. So, well, indeed, the responsibility of settling is big. I think we don't need to overstate it, and there's also the responsibility to make sure you're making the right decision for the state for that particular claim.
Thank you. Maybe even picking up on that, there's another question that has been asked about how would you know, what are the general considerations that would be considered to understand if a case that's coming before you is actually a good candidate for mediation, whether you're perhaps from the state perspective, as we're just talking about, so that you don't have that feeling of reticence, or even from the investor perspective as to what might be a good candidate.
If you want me to mention.
Sure, Mare, yeah.
And I think I tried to mention this earlier on, but a dispute that actually arises from a purely contractual situation, a contractual dispute that has been disguised an investment dispute, or that it's covered by an umbrella clause, might be a good candidate for a mediation for both parties, for the state and for the investor. It might have less potential of creating a difficult precedent, for example. It might involve less public policy questions of big importance. And so those sorts of disputes might be good for mediation. I'll let Justin mention or discuss what would be the case for the investor side.
Look, I think my starting point on it, Shane, is there are very few cases actually in reality where mediation wouldn't be a good tool to use, really very few. But I think probably the most important, both for the state and the investor, is if they're trying to secure a long-term relationship. Very often investment arbitration is described as the nuclear option. Once you start the arbitration, your relationship with the state is irreparable. And that, of course, is not always the case, but mediation is certainly an incredibly useful tool to prevent that nuclear option from being detonated. So I think when there's a long-term relationship on the table, that's an obvious one where a good case is made out, I think, for the use of mediation.
Perhaps this is asking a bit too deep a dive, but Meg, do you have in the cases that have gone to conciliation, have they been contract cases? Have they been treaty cases? Have they been in a particular area?
Yeah, I can't tell you off the top of my head, but I think one of the big things here is that they've gone to conciliation because there's a mandatory conciliation clause or a clause that allows at least the option of conciliation. And I know that, in fact, we see a number of these in investment laws in African countries. They seem to have used some of these, and so some of these cases have come from that situation, but I couldn't tell you the proportion that are contract versus treaty.
We are a few minutes over our time. Perhaps I can try. We've got a lot of questions here, and I apologize. We're not going to be able to get through to all of them. There was a question I read directed to Mare on the multilateral instrument. Perhaps I can tie it into another question that's been asked by our distinguished delegate from the European Union on the same topic, which is not just what reforms could it address, but could a multilateral instrument, what solutions could it bring to the problems in the use of mediation, specifically mentioned by Justin, for example, around the issue of costs, how it's linked to the tribunal questions of predictability, or would that depend more on the rules that were developed for the mediation as opposed to the multilateral instrument itself? And so perhaps in one swoop we can ask, and maybe this has to be our final one for the day, but Mare?
Thank you. On the question of what the proposed multilateral instrument could encompass, the idea is that it will be able to gather, englobe, encompass the majority of the reform options that have been developed by the working group, or at least the ones that we have discussed today. There are some that might be less obvious candidates. For example, the advisory center will not be included in a multilateral treaty, or does not, or not necessarily, except if a reference wants to be made. But generally, the idea is that we will move forward trying to develop provisions, protocols, chapters for a potential multilateral treaty if this is something that the working group in full agrees to. So the general idea is indeed to incorporate at least the most of the reform options that have been discussed and that are on the table to date. With regard to how the multilateral treaty might be able to address some of the concerns, that's what I tried to explain in the last part of my presentation. With regard to costs and predictability, I do believe that that is part of how the mechanism or how the mediation chapter will be drafted, and or the mediation chapter that will be incorporated in the multilateral instrument will be drafted. For example, if we end up agreeing on incorporating a mandatory mediation phase before going to arbitration, that would or has the potential of increasing the costs. If it's done on a consensual basis and it is provided that mediation can be used by the parties at any moment while the parties are trying to resolve the dispute, then of course this will entail less costs. On the question of predictability, also I try to establish that the multilateral instrument could try to help us set forth a uniform legal framework. A lot of that has already been done by the exit mediation rules. But there are a number of countries, for example, Latin American countries, that are not currently an exit contracting state. So the idea would be to incorporate the mediation provision based on best practice, based on the exit mediation rules, and based on modern international investment agreements, and try to establish a mechanism that would assist to use this tool further, but that it could also be helpful for as many states as possible.
Thank you, and thank you for all for indulging us in going a little bit over on the first panel. I note there were a number of questions that we simply could not get to. My apologies, but the good news is this is not our last discussion of this topic. Certainly in the working group, this, as I said at the beginning, is just the first. And so the questions that you have are questions that we will need to discuss and that we will need to move forward and think about the appropriate balances. So I'd like to offer now my thanks to Justin, Meg, Mare, and Jaemin. Now would be typically the time, I guess, we'd have a round of applause, but I'm not even sure that that's possible. So as my sincere thanks for this, and appreciate everybody for giving up their time, and to all for such active participation in the questions as well. It really does bode well for our work. So thank you, and I will now hand it back to our moderators. Thank you all.
Thank you. Thank you very much, everybody.
Yeah.
Thank you.
That's the end of session 1. We will now move on to the second session. The topic of this session is the multi-tiered dispute resolution process, also known as mediation protocol.
Well, good morning, everybody, and welcome to the historic building that we are in Hong Kong. And I wish in better times we would be together, but unfortunately we can't be. And much of this session will have to be conducted virtually. As you've heard from our previous speakers in session one, there still isn't a uniform set of rules for mediation in investor-state disputes. However, we will see that many organizations, in fact, have started to pioneer mediation. We heard from Matt Kinnear how ICSID, in fact, has been doing this. And you see, in fact, many other organizations, such as, say, the HKIAC in Hong Kong, with its set of rules for investor-state arbitration, actually incorporating some of the features of mediation. But we're still a little bit away, or perhaps more than a little bit away, from having a multilateral set of rules, best practices around the world, which is why people have to be creative when, in fact, they are faced with a dispute. And this session, in fact, deals with this particular aspect of trying to be creative within the set of rules that are in play in terms of any particular aspects of investor-state arbitration, or even a contractual situation where the parties are in dispute. We have here today a number of speakers, three speakers. We have Professor Wolf von Kumberg, we have Professor Jack Cole, and Ronald Sum, who's sitting next to me.
Thank you.
We have, of course, a paper, a very well-written paper by TKU and Andy Kwok, in fact, already in the website, and I hope you have read that. It's a very interesting paper, sets out, in fact, the history and the issues that we are faced with. And the issue being that since we do not have, in fact, a comprehensive set of rules, how can we be creative? How can we, in fact, deal with the situation right now, and using that experience, how that could be extrapolated and, in fact, applied in the future when we have to set up a multilateral set of rules, as has been discussed in the last session. So I'm going to start with Professor von Kumberg, but before I do so, I'd like you to bear in mind that each speaker will have about 15 minutes, and at the end of which we will have a set of questions from the audience. I would ask the audience to write down your questions in the chat room. I would ask the speakers not to answer them. We will deal with all the questions at the end after the speakers have spoken. But one final point, as you will see, in fact, and as has in fact come up from the previous discussion, is that there is a common interest by the host state, and the common interest, in fact, between the host state and the people who invest within that state. So therefore, there is a tremendous amount of, I think, common good when we try to mediate a dispute. So with that, I'd like to now invite Professor von Kumberg, in fact, to start. Wolf, would you like to start now?
Thank you very much, Tony. And let me see if I can get my screen working here. All right. So I'm coming at this perhaps from a slightly different direction than the previous speakers have. I am both an international arbitrator and mediator, which I've really done for the past 20 years or so. But over the last 5 years, I've been very much involved in helping to develop the field of investor state mediation. And really what I'd like to talk to you about is some of that experience. I think, the signing of the Singapore Convention in August 2019 actually is a great setting for what we're talking about. And as we know, the convention came into force in this September 2020. And through it, I think mediation itself has been given new credibility as an international process for the resolution of disputes. I was an in-house lawyer for several multinational companies for over 25 years and very much involved in ISDS disputes from an investor perspective. So one of the things I think we really have to look at now, and listening to the previous panel was very interesting because, of course, in the past, bilateral investment treaties contemplated that arbitration would be used to finally resolve disputes between investors and states. Mediation was not even mentioned or contemplated to have a role in this type of dispute. And we heard from Meg a little bit about the fact that there was a conciliation, and conciliation rules were provided within ICSID. But those rules, and if you look at them carefully, they are very unlike anything that you would consider in modern mediation. And so it's important, I think, for us to understand why those conciliation rules might not have been used. I don't think you can equate that to mediation. They really weren't used because really at the end of that conciliation process, the tribunal rendered a non-binding opinion, and most parties therefore never really used it and went directly to arbitration. The cooling off period, which you also heard about, and that's provided for in BITS, which is usually 3 to 6 months, was typically used not to try to find a resolution to disputes, but rather to prepare for arbitration. And in many cases, states, because to a certain extent, their own administrations were perhaps somewhat dysfunctional, utilize that time actually to find out more about the dispute itself, and so never really had the opportunity to utilize that time period for the resolution of the dispute. Therefore, what we're really dealing with here when we try to introduce mediation to a system that has never used mediation is really a psychological barrier that has to be overcome when we try to use any new process within an existing system. And as already has been said by the other speakers, states are very particular, and it's very different than dealing with arbitration or a dispute in a normal commercial situation. And so I think I agree very much with what some of the other panelists had said, that states require a framework to permit them to mediate. So there has to be a framework of some sort before we can really kickstart mediation within ISDS. So looking at where we currently are with respect to new model bilateral investment treaties and agreements, what we're talking about actually is the provision for mediation in many of those. And so we see here a number of those investment treaties that do already provide for mediation. So the Netherlands Model Bilateral Investment Agreement of 2019 includes a provision for mediation. The CPTPP between Canada and 10 Asian Pacific region countries, which entered into force on the 30th of December 2018, also foresees the use of good offices, conciliation, and mediation. And here in Hong Kong, the CEPA investment treaty between mainland China and Hong Kong provides for consultation and mediation as the dispute resolution mechanism. Uniquely, under that treaty, there is no arbitration provision at all. Another interesting, I think, and perhaps novel approach is that being taken by the European Union. The agreement for the termination of bilateral investment treaties between the member states of the European Union, which was actually entered into in May of this year by a majority of the member states, provides in Article 9 a settlement procedure that can be entered into, and goes on to provide that the settlement procedure shall be overseen by an impartial facilitator. The word mediator isn't used, but we know that mediation and mediators are actually referred to as facilitators. And that's with a view to finding between the parties an amicable, lawful, and fair out of court and out of arbitration settlement of the dispute, which is the subject of the arbitration proceedings. The settlement procedure shall be impartial and confidential. Each party to the settlement procedure shall have the right to make its views known. So you see there are a lot of attributes of mediation actually coming through. And I'd like to turn with a little more detail to CETA, which has already been referred to before, the Comprehensive Economic and Trade Agreement between Canada and the European Union. And that provides a three-tiered dispute resolution process. And I think this will very much become the model. So you start with consultation, which is a required step under the agreement. You then have mediation, which is a voluntary step. And as we've already heard from the previous panel, that is an important factor, that it's not mandatory, but is voluntary, which is very much the case in many commercial mediations as well. It's very rare that they are mandatory. And then failing that, you may submit the claim to the tribunal. So you've got a three-stage process there. And if we look at how these tiered processes actually work, and looking at them perhaps more from a commercial perspective, because many commercial contracts nowadays actually have a tiered dispute resolution process. What that actually means is that when a dispute arises, the parties are very much guided then through these agreed tiers, normally starting with negotiation or consultation, followed by mediation, failing which the parties proceed to arbitration or litigation. There is typically a specified time period for each step, and one may only proceed to the next step if the prior step fails to end in settlement within the specified time period. So we see that modern BITs are now emulating this tiered approach in the context of ISDS. And I think that it will actually assist in them being utilized by states, particularly if they become part of the agreements themselves, or as was previously said, if they were actually put into the contracts that states enter into with investors. We've already heard about the obstacles to effective application of mediation. Last December, we organized a colloquium at Harvard, and we convened stakeholders in the ISDS process, including investors, states, institutions, and academics, to review these obstacles that have already been discussed. And I think without perhaps repeating some of them, what was identified at Harvard was really that the primary obstacles were providing adequate authority to settle to state officials, transparency versus confidentiality, which has already been discussed. In many state administrations, there is opaque responsibility, so it's not clear who has responsibility for particular disputes when they arise. We've already talked about state officials avoiding liability for taking decisions. Another interesting one, which hasn't come up yet, is state budgets, because it becomes unclear sometimes within the state as to who pays for a mediated as opposed to arbitrated outcome. And of course, if a particular government department might have to pay for a mediated outcome, But if it goes to arbitration, it comes out of the general administration of the state. That might actually make it a motivation for a government department to actually kick the problem into arbitration rather than trying to resolve it themselves. And then, as was already mentioned, public policy concerns and whether those can actually be mediated adequately. But the prime obstacles that were identified, and I think that has to be emphasized, is the lack of awareness of mediation as an alternative in ISDS, perhaps less so on the investor side, because many investors are involved in mediation in commercial disputes, but more so on the state side. And I think, as was already discussed, that will require more education of state officials as to what mediation is and how it can be utilized. And then the second important factor, which we already have discussed now, is insufficient legal framework to support mediation and mediated settlements. So those are the two key elements, I think, that have to be addressed before you can even start looking at the other obstacles. For those who are interested in continuing to follow these developments, I just want to mention that we're having a follow-on conference to the Harvard colloquium, which is going to be heard virtually at the British Institute of International and Comparative Law, BICL, on the 8th and 9th of December. So you're all welcome, and there are further details at the BICL website. So just looking at quickly some of the institutional developments that have already occurred, as Tony was saying, there have been a lot of things that have over the last few years already been occurring to help overcome these obstacles. The Energy Charter Treaty, in particular, the Secretariat there, which is a grouping of 54 states, which establishes a multilateral framework for cross-border cooperation in the energy sector, has been very active in looking to see how mediation can be utilized within its rules. And while it has a reference to conciliation in the rules, there's no specific process. And so we worked with the Secretariat to actually create a mediation guide for the member states so that that educational process could take place where they could learn about what mediation was and how mediation could actually be utilized within those particular rules. But the Secretariat also understood that it wouldn't be sufficient simply to have this guide, but also to help create a protocol for states within which they could then mediate. So as we already discussed, a legal framework for mediation to take place. And so the Secretariat has actually drafted a model instrument on management of investment disputes, and that was published in December 2018. And I would encourage particularly states to look at that, whether they're members of the ECT or not, because it has a lot of good and functional ideas in it as to how states can actually put a structure in place to enable them to mediate disputes. I think very important for the acceptance of mediation is what ICSID has been doing and the reforms that Meg had already described in the last session. In particular, the fact that ICSID itself has now proposed mediation rules gives mediation, I think, a strong endorsement. And I believe will assist very much in states taking up mediation. And this really follows up on the IBA investor rules, which have already existed since 2011. But I think because of the lack of a framework within which states could mediate, have really not been taken up. But they're also an excellent set of rules that can be utilized in ISDS. There have, in fact, been several important investor-state disputes that have been mediated, and I understand from the previous question that these are not reported. And of course, mediation in the sense, as we've already discussed, is confidential. But interestingly, as the ICSID rules say, the fact that the mediation has taken place need not be confidential. I think that's an important point. I could just point to a recent reported case, which is that of the Dominican Republic and Odebrecht, that was mediated this last January by Mercedes Tarazon, who's a well-known international mediator. And that was mediated under the ICC mediation rules and led to a settlement agreement between the parties. So that is a case which indicates that mediation can be used successfully and bring a positive result both for the state and the investor. Just going back to the Singapore Convention quickly and its application to investor-state disputes. I think it's important just by looking at the preamble to the convention, which says recognizing the value for international trade of mediation as a method for settling commercial disputes in which the parties in dispute request a third person or persons to assist them in their attempt to settle the dispute amicably. And I think that says it all. And I think while there are still perhaps differing views as to whether the convention will apply to mediated investor-state settlements, it's difficult to see how states, having entered into this treaty, will exclude it from application to themselves. And one can just look at the success of the New York Convention with respect to arbitration as a precedent for the argument that states will rarely exclude the application of a convention of that sort to themselves. So I think it will certainly have application in this area as well. So just very finally, I'd like to just spend a few minutes on where we go from here. We have already heard, and we know, many of us from experience, that mediation is cost effective, it's relatively speedy, and it's an efficient way to deal with disputes. But more important, as it has already been raised, it allows for relationships to be maintained. And clearly, in this particular area, as Meg has already alluded to, it's important for states seeking foreign direct investment because it's an ideal way to convince investors that there is an effective way to deal with investment issues. So making mediation part of the dispute resolution process within the state itself, so formalizing it in that fashion, could actually be very effective with respect to FDI. And I think it's also useful, just spending a moment, of course, we all are familiar with the effect that the pandemic is having on international trade. And it's certainly going to have an adverse impact on many investments, simply because states seeking to protect their citizens in a health crisis may very well also thereby be interfering with particular investments. And so there may very well be many disputes arising out of the pandemic itself, but these require existing legal relationships to be renegotiated. And that's something that mediation, but not arbitration, can help achieve. So there's a very important role that mediation can play in the current situation with respect to the pandemic. It's also an effective tool to use together with arbitration, and we've already talked about that. It's not exclusive. It's not either mediation or arbitration. It's actually part of a holistic system where the two processes complement each other and can run either sequentially. So you've got mediation, it doesn't work. You go to arbitration, as was already said. It can reduce some of the issues that go to arbitration because you may settle some issues and you've got a smaller number of issues that then go to arbitration with the savings of cost and time that result from that. But it could also be used concurrently. And I know my fellow panelist, Jack Coe, will probably be addressing that because that's a very important, I think, consideration as well, that you can have mediation and arbitration run concurrently with each other and can come to very much better results as a result of that. Med, which is talked a lot about in commercial arbitration. So first, serving as the mediator then serves as the arbitrator, same person. And then if the parties then want to go back to mediation, the arbitrator becomes the mediator again. A lot of concerns around that from a lot of people, but it's still a consideration that should be talked about in certain parts of the world, particularly in Singapore. In fact, it's become part of the process that can be chosen. So it may very well have a role in ISDS as well, and I think that should be explored. So just to finish off, I think mediation is inevitable in the ISDS world. It's going to become part of the landscape, and I think it will be integrated with the traditional arbitration process. So with that, I'd like to turn it over to the next speaker.
Hello, am I being heard?
Yes, now we go on to Jack.
Hello. Just doing a sound check. Am I being heard?
Yes, you are.
That's lovely. Thank you very much. It's Sunday here, of course, and causing my wife to ask, since when are you teaching on Sunday? And I said, oh, this is for my friends in Hong Kong. And she said, in that case, you better put your tie on, which I dutifully did, but I refused to depart from my slogan for 2020, which is to remain calm and carry on. The earlier speakers did a good job at addressing my topic, which is considerations in the design of effective mediation protocols for international investment disputes. And as Wolf mentioned, I'm going to spend the last part of my remarks outlining one possible hybrid approach to combining arbitration and mediation. And indeed, it would involve possibly teams of mediators shadowing a sole arbitrator. I'll come back to that, but I do think I've been called upon to identify some of the considerations. So I will draw on what the earlier speakers said and perhaps redouble some of what is said, maybe in my own perspective. I'm, of course, an enthusiastic supporter of mediation, even though most of my professional life has been spent in arbitration. But I'm going to start with the notion that I think it's unrealistic that mediation will fully supplant arbitration as an investment dispute mechanism. I mean, I think investors, and more importantly, prospective investors, are very attached to it. It gives them a mechanism for avoiding local courts and a binding remedy in the event that the promises made in the treaty, that states fall short in their treatment based on those promises. And obviously they control the process, not least the appointment of those who will be their decision makers. And in the end, they get a result that's enforceable globally in one of the two principal conventions, either the New York or ICSID. Of course, it's far from perfect, right? We all know the long list. It's slow, expensive, depends on a governing law, which is not always predictably applied. And certainly the outcome tends to be very fact dependent, not necessarily nuanced with respect to the way it can treat the balance of equities between the two parties. I mean, it's, after all, confined to a legal dispute. And of course, in the end, the disputants can't control the outcome and often are very surprised by it in arbitration. Also, arbitration is not really set up well to account for significant third parties, at least in a direct way. And the above-mentioned combative nature we're all familiar with, and it reduces, of course, the chances that the parties will remain on friendly enough basis that the investors will want to continue to invest in the country. For its part, we know that mediation is successful in a high percentage of B2B cases. At least the data out of the United States and England and others show that there's a very high rate of settlement using a mediator. So the question, of course, is can we transfer this to the investment realm? We certainly know that investment disputes already settle at a substantial percentage, substantial enough that it confirms that there's nothing inherent in investment disputes that prevent them from settling. And I tend to think that the introduction of a neutral third party is not going to lessen the number of settlements, and I tend to think that it will certainly increase the number. I note that when I look at the settlements that occur just in the bilateral basis, that the full range of types of disputes settle. But I am very enthusiastic about this prospect of a second generation analysis or systematic approach to the questions we've been talking about here now for 15 years, to identify disputes that are particularly apt for mediation. We talked about contract-based disputes, or those that come up to the tribunal under an umbrella clause, and I certainly think that we need to try mediation, especially in those places where it's got the highest chances of success. Interestingly, when I looked at a sample of the settlements that occurred during investment arbitration, contrary to what I initially guessed, a lot of those settlements don't occur during the cooling off period, but rather deep into the arbitration process. And I think that's in part because the states don't necessarily have a good grip on what the dispute is early in the process. It continues to be at that stage just a fact-finding exercise. Of course, an important consideration in all of this is that while mediation is a very powerful technique, it remains voluntary. And here I agree with the earlier panelists that said, on balance, we ought to preserve the voluntary character of mediation. Although, and I mean, I just simply think that states won't willingly participate in a treaty that requires them in a compulsory way to mediate. There's lots of problems with trying to do that. Although I think at the margin, we need to think about ways that we can incentivize them, to use a word, to some inducements to promote mediation. In general, relatedly, I think we also need in our architectural design to understand that party autonomy is very important, and that flexibility is important, and one size does not fit all. And the most satisfying process is the ones that the parties on a bespoke basis, through collaborative rulemaking, organize for themselves with the help of the neutral. So worth underscoring perhaps twice is that, and we've all been talking about this is the big question. It only works if the parties can be convinced to participate long enough for the process to gain momentum. I like the notion of there being in the structure that's being created prompts or cues or triggers analogous to the triggers one finds in commercial contract disputes clauses that call for MEDAR, for example, a mutual promise that we'll try mediation before we go on to something else. I think Wolf referred to agreed upon tiers. The difference in my model is that these prompts and cues would occur throughout the arbitration process. They would be enforced by, or they would consist in things found in the treaty, in arbitral rules, and indeed in the procedural orders issued by the arbitral tribunal. These would be preset reminders that to the parties that the mediators appointed by them, or indeed otherwise assigned to the dispute, stood ready to engage, or as the case may be, to re-engage. That is, to invite them at certain predefined structures, or junctures, I should say, junctures that ordinarily are associated with shifts in momentum. For example, right after the hearing on the merits, or after a big battle on jurisdiction or something like that. One product of these triggers, by the way, is it relieves either party of the awkwardness of having to invite the other party to mediate. So the prospect of being seen to be weak by virtue of introducing the idea that you'd lack confidence if you introduce a mediation, that seems to be diminished by having these triggers. Whether the triggers will be successful, of course, depends on the other theme that seems to run through all of what we're talking about, and that's the extent to which the parties are sufficiently familiar with the process and sufficiently convinced by the potential advantages for themselves of using it, And here we're talking about, again, capacity building and various influences, both educational, that help the participants, notably the states, to see that mediation gives them a good chance of improving on whatever result would occur in arbitration. And relatedly, again, the problem, and there's not a simple answer to it except for ongoing changes in culture, state officials ought to feel free to participate both in the mediation process, but also in bringing the dispute to an end without fear of suffering some kind of personal detriment, like a corruption investigation or a demotion on their career path. And so it's an ongoing problem, but these things can be dealt with through education. I think I'm optimistic that this kind of capacity can be built. I mean, if those of us who think back to the mid-90s when investors discovered the arbitral claims mechanism, starting with NAFTA and then outside of NAFTA, many of the states on the receiving end of these claims were not well situated to handle them. They lacked knowledge and know-how, but over time, of necessity, they became rather skillful repeat players. And I think that mediation skills and enthusiasm about harnessing its advantages can be learned by both investors and states. I admit that the mediation proposition is a little different. In other words, in arbitration, you force states to get the experience. Here we're again talking about a voluntary process, and as I've said, I hope that voluntary nature will be preserved. So states must be convinced through other means that the mediation benefit them. Big selling point, I think, is that the parties take control of the outcome and avoid what might be a surprising zero-sum outcome, quite unpleasant in some cases. Again, the culture needs to be, I think, changed as part of the educational process. And so it shouldn't be necessarily an easy thing for a state official, or for that matter, company representative, to say, well, gee, we should have won, and the tribunal simply got it wrong. And I know we spent a lot of money and in the end didn't get what we expected. Simply a matter of resource management in a world where disputes are inevitable. So there is that selling point. Another selling point might be that in addition to the outcome being controlled by the parties is something a little more subtle. And that is this equal opportunity to air grievances. And it sounds a little squishy, but think about it. In the arbitration process, states are disallowed from bringing counterclaims most of the time. And so one advantage of mediation is it gives them an opportunity to air their grievances against the investor concerning the investor's conduct. Equally, third parties might be able to be brought to the table, not so in arbitration. And those third parties often are very influential in the overall thrust of the dispute and in the direction it might take. In thinking about the proper mediation arbitration hybrid, I'm influenced by what I've observed as the natural ebb and flow in the arbitration process in particular, where disputants over time come to know their respective cases better than when they started. It's a different case that when you started with, and often you become to know not only some of the strengths, but also the deficiencies. And it's that tendency of the dispute to evolve as the amount spent mount, as you become aware of witnesses that were weaker than you thought they would be, or defenses that you thought would work and don't, that this concurrent process seems attractive to me. And let me just outline it in the next 3 minutes, which will exhaust my time. The model, at least one model that I think would work, is for existing BITs and new BITs to contain an attachment or an elective protocol, if you will, that proposes a hybrid approach. Either party could elect to make this apply once the arbitral claim is launched under a BIT. The format would be subject to the parties customizing it, but the basic approach would be, the default that is, would be for, instead of 3 arbitrators to function, there would be a sole arbitrator who would be appointed in the usual way. Contemporaneously, each party would appoint 1 mediator. The 2 mediators in turn would be duty-bound to be independent and impartial and would form a team. The arbitrator in turn would press forward with the arbitration in the usual way, enjoying, one would think, additional nimbleness by virtue of being a sole arbitrator and not having to deal with 2 other arbitrators. The 2 mediators, in operating as a team, independent of the sole arbitrator, would nevertheless have some interaction with the arbitrator in various ways. For example, the arbitrator should supply the mediators with submissions, allow them to attend the hearings, etc. And the way I look at it, my visualizing the process, is the mediators would engage in the cooling off period, while in many cases they're just fact-finding, but they'll at least begin to understand the case. Success would come later in the process, and as I've studied the settlements in the arbitration realm. The arbitrators, in part of this conscious parallelism, if you will, the arbitrator's first procedural order might set forth the set junctures during which the mediators would be predictably invited to shadow the process or engage with the parties during these windows. They would operate using the various techniques that mediators use, including caucusing. The mediators, I think it's vital that they are persons who understand not only arbitral jurisprudence and the arbitral process, but also be people of exceedingly high repute in the international community. These are attributes that I think will help promote settlement, because they'll be able to, with credibility, point out the weaknesses in the parties' cases and demonstrate the risks of not settling. And the stature of these people would add to the, I would say, saleability of the result. That is to say, the result engineered by these parties with the help of these noted arbitrators could be sold to the various constituencies with greater ease by virtue of who the mediators were, who crafted the outcome. I call this the vouching function. It answers to some extent the reserve that government officials might otherwise have. The beauty, I think, of my system is that even if settlement doesn't occur, and this was mentioned by our earlier colleague, much can be done to improve the arbitration process, whether it's helping the parties with disputes over document production or some other kind of thing. When, of course, settlement is reached in the context of the arbitration, the parties may request that the sole arbitrator render an award on agreed terms, which in turn would be enforceable under the prevailing view under the New York, and for that matter, the ICSID Convention, depending on which one applies. Alternatively, now with the Singapore Convention, particularly that may be an option that they would choose as well. Understand that if they don't settle, the arbitral tribunal would move forward and issue an award in the usual way. And again, nothing would be different about that award than the usual award that would be rendered. I'll stop there. I hope we get some questions on that. This is one proposal I have for the sake of discussion, and I hope that we can maybe talk about it a little bit. I will stop there. Thank you.
Who's going to talk about, in fact, a regime where the only way of disposing of a dispute is by way of mediation. Ronald.
Good morning from Hong Kong, and thank you, Tony. Thank you, Jack, and thank you, Wolf, in the deliberation and moderation. Now, for the audience, if you have not read the background paper by Professor Yu and Andy Kwok, I urge you to do so. It's not very thick, it's only 33 pages. Now, I'm going to talk about innovation of the investment mediation rules under the CEPA Investment Agreement. If I can get my PowerPoint working. Okay, I'll quickly go through what I'm going to talk about today. We're going to talk about CEPA. I'm going to give a very, very quick introduction of CEPA, a couple of seconds. In particular, then, I'll be moving on to the more detailed CEPA investment agreement, and in particular, the CEPA mediation mechanism. And finally, to discuss as a practitioner, as the user, my thoughts about the CEPA mechanism. Now, what is CEPA for those audience who are not from Hong Kong? It's a bit slow. So what does it cover? It's called Closer Economic Partnership Agreement. What does it cover? Trading goods, trading investments, etc. And underneath CEPA, there is something of the investment agreement similar to the BITs. Now, it protects and benefits investors from Hong Kong and foreign investors going into China from Hong Kong. I'll get it back. Now, if you look at the amount invested from Hong Kong or through Hong Kong to China, you can see the slides, is 1,100 billion as at the end of 2018. And through CEPA, there are already 204,000 applications made. That means the Hong Kong investors get a CEPA certificate investing into China. Now, this is only the figures from Hong Kong or through Hong Kong into China or to mainland. I am very certain that the mainland figures, the investment figures into Hong Kong will be equally significant, if not more significant. Now, under CEPA, we have what we call the investment agreements, or similar to the BITs. The structure is pretty much the same. It comes into 3 levels. The first level is more like the BITs. The second level is in relation to what we call the CEPA mediation mechanism. And finally, the third level will be the rules from relevant mediation institutions. Now, what does it mean to investors? It protects the business. It enjoys a safe environment to invest. Now, one thing regarding the investment agreement, there is no arbitration. No arbitration is involved, but there are other means of resolving disputes. Obviously, one of them is mediation. The rest, for example, judicial proceedings, conciliations, complaint mechanisms in handling investment disputes, etc. It is all set out in the investment agreement. Now, moving on to the mediation mechanism agreement, these are the key principles. The mediation principles, submission conditions, the settlement, confidentiality, and notification. Now, when we talk about mediation principles, of course, there are the parties. Who are the parties? The investors. It protects Hong Kong and mainland investors. The other parties are obviously the governments, the cities, the municipal councils, etc. Now, there are different mediation institutes under the investment agreement, 2 from mainland and 2 from Hong Kong. You can see from the slides, CCPIT from mainland, CTEC from mainland, HKIAC and the Hong Kong Mediation Council from Hong Kong, and the Mainland Hong Kong Joint Mediation Center. The scope is in relation to disputes under the investment agreement in CEPA. And in mediation, it talks about consensus. It is voluntary. Both parties mutually agree to mediate, which is the basic principles of mediation. Now let's talk about Hong Kong investors going into China and how it is being protected. As I said before, there are 2 mainland institutions, CCPIT and CTEC. And under both institutions, they have their own separate rules, which are more administrative in nature. For example, CCPIT CTEC is the investment dispute mediation rules of CEPA investment agreements, respectively. Okay. So far as concerns the mediators, for CCPIT, there are 91 mediators, and for CTEC, okay, 56 mediators from mainland, 13 from Hong Kong, and 4 from Macau. Now, for mainland investors going into Hong Kong, 2 mediation institutions, the HKIAC Hong Kong Mediation Council and the Mainland Hong Kong Joint Mediation Center, they have, of course, their own administrative rules. That's the investment agreements under the framework of the mainland and Hong Kong CEPA mediation rules. Now, there are 27 mediators at the investment mediators at HKIAC and 21 from the mainland Hong Kong Joint Mediation Center. Now, for Hong Kong, these mediators are handpicked, so to speak, and they have to go through rather painful process. Training, I can say that it is painful because I have gone through those painful process, and you have to pay a fee as well. Now, obviously training, you can see from the slides, tender training within 9 months before designated as mediator. Of course, the background, it is not as if you have not done anything. You have to have experience in this type of, in mediation as a start, and in investment mediation. There is an accreditation procedures. It is under the Hong Kong MAO, as we call the Hong Kong Mediation and Accreditation Associations. As I said, the experience, language skills, Chinese and English, including 普通话, okay, Mandarin. And of course, the undertakings. The training and the undertakings are the painful part because you will receive a letter at the end, a rather long letter, I would say, setting out your undertakings to follow the rules of CEPA investment agreement. Now, there are certain conditions on submission of investment dispute mediations. There's a limitation period. You have to commence the mediation within 3 years. I've heard that this can be waived in a sense because, after all, mediation is an agreed process. Both parties can agree to mediate even if it may be outside the 3 years period. Qualified investors, you can look into the qualified investors in the investment agreement. For mainland and investors coming to China, basically, in short, any type of investments in Hong Kong will be sufficient. For Hong Kong investors going into mainland, it is basically the same, but one more condition is that you will need to obtain what we call a CEPA certificate, when they are going into mainland for investments. Consultation, of course, you will see from a later slides about the flowchart. Consultations or more conciliations must be done 1 month prior to delivery the notice of mediation. I'm going to talk about that further later on. Waiver. Waive the rights of initiate or continue dispute settlements under the agreement between any other parties and the government authorities. So it is an agreed process. Of course, if it is a successful mediation, then there will be a settlement agreement. The settlement options, monetary compensations, restitution of properties, or for that matter, any type of arrangements to achieve what we call a win-win process in Hong Kong. Enforcement will be based upon the jurisdiction of the investment. Enforcement in Hong Kong, it's because, after all, a settlement agreement is a contractual agreement. The usual contractual rules will be applicable. For enforcement in the mainland, the same principle applies, of course, together with the provision dealing with actions relating to settlement agreement issued by the Supreme Court in 2002. Now, of course, there is always the confidentiality issues in mediation. Now, in light of time, I'm going to skip that because I want to go into my flowcharts. There's a notification procedures where both Hong Kong and mainland authorities will report to each other as to the number of investment mediations happened and whether these rules can be fine-tuned further. Now, this is a typical mediation procedures under CEPA. You can see there is the conciliation process, the amicable consultation between the two parties before you can actually submit a notice of mediation. Now, after the conciliation, if not successful, then you proceed with the mediation institutions. You pick which institutions you prefer. Obviously, in Hong Kong, is the HKIC, HKMC, Hong Kong Mediation Council, and the Mainland Hong Kong Joint Mediation Center. Now, once you have picked it, you have entered into the mediation procedures under the mediation mechanism, the CEPA mediation mechanism. There are slight differences you can see from the flowchart. Okay, within 15 days of the for mediation conducted in the mainland, and 21 days for mediation conducted in Hong Kong, after the respondent receives the invitation to mediate from the mediation institutions. Okay, the respondent will confirm or will show whether they have intention to mediate or not. Obviously, if they have no intention to mediate, the process ends there. If they do, it will proceed to mediation. Now, my experience is that I think many of the panel speakers have discussed this before. Education is important. Education not only to the practitioners, but also to the users and also to the authorities. In this respect, as a practitioner, I've conducted this type of mediation before, and many of the authorities, if they are educated properly and the users know about mediation, they are actually not very, they are actually quite agreeable to mediation. Okay, that is the experience that I have. One thing, it's particularly in Hong Kong, is the Mediation Management Conference, where it's a compulsory mediation management conference. For those Hong Kong audience, is similar to the district court, the case settlements conference, where all the parties is together, talk about the rules, the procedures, whether there should be other parties involved. It's more administrative, is to streamline the mediation process. Now, it is not all just talk, because there is the latest CEPA mediation case. It's a Hong Kong investors going to mainland China, involved in high-tech business. It's confidential reasons, can't release the names. It's $20 billion. Joint mediators played a key role for CEPA mediation in mainland. Is 2 mediators. For CEPA mediation in Hong Kong, it is 3 mediators. I hopefully, fingers crossed, it will likely reach a settlement. Now, obviously, we have been talking about the difficulties in persuading authorities in proceeding with any mediation. Okay, that's the first panel. So long as it's a win-win situation, the authorities get benefits and our clients do get benefits, then mediation is the way to go. Now, for users, for practitioners, the set of rules are very clear. Okay, the practitioners will need to tell the clients that what is happening. So a clear set of rules is important. And under the CEPA mediation mechanism, you can see that I can literally, with my IQ, I can literally draw up a flow chart. So it is a very clear mechanism. Hong Kong is a global gateway into mainland. Similarly, Hong Kong is a gateway to mainland into the world. Now, it is voluntary. You can't force the parties into the process, but I mean, in so far, many authorities are happy with the system, as far as I know. Now, it achieves a win-win situation. Hopefully, this CEPA mechanism will be a reference point for UNCITRAL to draw inferences from, because so far it has been working pretty nicely. And Hong Kong is a supporter of mediation, not only on the CEPA, but on the local fronts as well. So that is my presentation on CEPA mediation. Thank you.
Well, thank you very much, Ronald. And thank you, Wolf and Jack, for very interesting presentations this morning. That carries on, in fact, from the previous discussion by the members of the previous panel. And it appears to me that, in fact, within all of these discussions so far, there is a central issue, which is this, that if one go into mediation, at the end of the mediation process, there has to be an agreement. And in making an agreement, one has to make a decision. The question, therefore, is what responsibility does one undertake, in fact, in reaching that decision? As a litigation lawyer of over 40 years, one of my main tasks, in fact, in advising clients is that is the responsibility that they have to undertake in reaching a settlement. And often, in fact, they ask me just 2 questions. One question is, how can I explain this to my boss? The other questions in terms of directors would be, how can I explain this to my shareholders, in fact? And often I have to tell them, well, you take advice from the best people that you can, from your experts and from your legal advisors, and then make a decision which is devoid of personal interest, and of course, made in the context of the best interest, in fact, of the organization that you represent. Now, that is, in fact, the central issue, as we have seen, is that in order to really progress mediation, and that's one of the main reasons why, in fact, the treaties that we have seen so far in international investment tends to skew towards arbitration is that arbitration, of course, is a decision made by a third party and not by yourself. And if a decision is made by yourself, then you take upon the responsibility of having to explain yourself. And which is why, in fact, we need to have not only transparent rules, but in fact, rules within the host state and also within, in fact, the investor to ensure that when you make those decisions, that will have to be made in a way which is explicable, which is reasonable, at the same time, of course, within the constitutional constraints of your particular organization, which is why, of course, we have this discussion. Now, we have a number of questions today, some of which have already been tackled, in fact, by both Jack, Wolf, and by Ronald. But the primary decision, primary question that we may have to address, because this is an intersessional meeting before the meeting of the Working Group Pre, is what can Working Group Pre do in order to progress this discussion? What do you propose that Working Group Pre should do? So I put this question to each of the three panelists, and I will start with Wolf. So leading from this discussion, what do you think Working Group Pre should do?
Well, I think as was already discussed in the previous panel, and just from the experience that I've had with respect to reviewing the obstacles to the use of mediation, the first thing is really to create a framework within which states and state officials feel confident to mediate. So I think that's one of the things the working group does have to concentrate is coming up with a model that can be implemented by states through which they can mediate.
Thank you. And Jack, anything you'd like to add to that?
Yeah, I just to agree completely with what's been said about there's something magic about putting a positive statement of principles and framework together, something that one can refer to. It somehow legitimizes it. And I think the extent to which we can do that's very useful in combination with all manner of capacity building exercises and drawing on, Ronald talks about some wonderful successes they've had there. We've seen an ICC case and emphasizing those real situations that produced good results, studying them to see why they succeeded. And at the same time, I think working on the culture that allows ownership of decisions as a function of resource management. I'm not sure what Working Group 3 can do, except to maybe continue with the preambular discussion and lots of sort of working group commentaries suggesting why mediation is so vitally important and why there is a tremendous waste of resources and, in fact, retrograde reactions, circumstances where states have counted on one result and gotten another result. And so you can blame the arbitration tribunal only so much for a $2 billion award, when in fact, if you could have made it gone away for a third of that by virtue of vending in some other things outside of the legal dispute, new values of various kinds that skillful mediators know how to do. But one at some point has to be brave and stand up to what will always be there in the world of critics of what governments do. But as long as it's transparent to the extent possible and justifiable on pure economic, concrete, showing results, here's the downside risk, here's what we accomplished in the settlement, that's why it's a win-win, here's what we avoided. Chronicling those kinds of things and perhaps the working group can in fact have case studies that would demonstrate that upside benefit and the downside risk of not doing that.
Thank you. Ronald, anything to add?
I agree with everything being said. I would stress that education, capacity building is very important. As a practitioner, the user will ask, please explain to me the process. So clear set of rules is also very important. And then the next question will be, who will be the mediators? Okay, have they had any training before? So capacity building of the mediators are also very important. Okay, education to the authorities, it's a must, because after all, it's a mediation, it's a voluntary process. The government will have to be comfortable, okay, with the process. So that will involve lots of, I would say, promotion, good framework, good capacity building, and on the government side as well. So that's my suggestions.
There's one final question from among the questions here is that in mediation, you need to have, in fact, parties who are able to, on both sides, who are able to make decisions. And in investor-state disputes, it's often very, very hard for one body, sometimes it's a municipal body, to make that final decision in coming to an agreement, to a successful mediation. So what do you suggest should be done? In fact, in order to create a system whereby effective decision-making could be made by states. Anyone would venture, perhaps? I think Wolf is about to start, and perhaps we'll ask Wolf again.
To say, I mean, that just going back to the ECT experience, that's something that the Secretary had recognized, that states actually have to implement before any dispute arises a protocol internally, which sets out the framework for the organs of the state to deal with disputes generally. So that's already in place when the dispute arises, so that there is a mechanism to determine where that dispute goes within the state and who has responsibility for it. Whether they create a committee, which is one of the things they can do, where there are a number of departments that might be involved in the decision-making, whether the decision-making goes to the Prime Minister, for example, ultimately, but that there is already a clear mapping of how that dispute will be dealt with.
I see Jack nodding his head, and anything you'd like to add to that?
Well, just that what he said is absolutely true. If you look back to the mid-90s in arbitration, it was often the case that there would be these inter-ministerial disputes over who actually got to defend the state. Is it the State Department or Ministry of Justice? Who is it? And what other ministries have to be involved in the defense because it was not beforehand thought through, and it took a long time in some cases to actually arrive at an internal mechanism that was well functioning.
That very much accords, in fact, with my own experience in commercial dispute resolution. And I often advise, in fact, a board to have a special committee to advise the board when the time comes. Now, this rather means really the end of our session because we've run out of time. But this afternoon, I'd like to encourage parties and everybody watching now and perhaps other people to join our session 3, which is on hybrid models for resolving international investment disputes. And it starts at 4 p.m. Hong Kong time. So we sign off now from the French Mission Building in Hong Kong. And we invite you to join us again at 4 p.m. today, Hong Kong time. Good day to you.